Okay, let's talk about navigating the wild world of international patenting. You've got this brilliant invention, you want to protect it everywhere, but the process, it can feel a bit like hacking through a dense jungle, right?
Oh, absolutely. So many rules, so many steps.
Where do you even find a clear path?
It definitely can feel that way. And while the Patent Cooperation Treaty, the PCT, it offers a fantastic pathway to manage that process initially, it's definitely not just one single step. There are crucial decision points and, distinct phases within that PCT journey itself.
Which is exactly why we're here. Welcome to the deep dive, where we grab complex information and, well, wrestle it into submission, making it understandable and actually useful for you.
Welcome. Glad to be diving in.
This particular deep dive is actually part of a larger project we're doing. Think of it as cracking open the Manual of Patent Examining Procedure, the MPP.
That huge rule book.
Exactly.
Yeah.
The one that governs U.S. patent practice, including how international applications pass through the USPTO. We're going section by section, aiming to give you digestible insights.
And today, we're exploring Chapter 1800, which covers the PCT, and we're really focusing our laser on one specific, very important section, MPP Section 1864.
Section 1864, and the title is The Demand in Preparation for Filing of Demand. Just the name, the demand, sounds kind of serious.
It does, doesn't it? It immediately tells you this isn't just like some minor detail, it's a formal action you might need to take. And yes, it is a significant step within the PCT process.
Okay, so let's unpack this right from the start. You've already filed your initial PCT international application. People usually call that the request under Chapter 1 of the PCT. What exactly is this demand under Chapter 2, and how is it different from that initial filing?
Right, that's the key distinction. What's interesting here is that the demand is a separate, subsequent formal step. It's not part of your initial application filing or even the initial search phase under Chapter 1. Filing the demand is specifically your request for international preliminary examination.
Examination, okay.
Yeah. Think of it as asking the examiners to take a deeper, more analytical look at your application after the initial search is done and you've gotten some feedback. It signals, a higher level of commitment to pursuing protection in multiple countries.
Ah, okay. So Chapter 1 is kind of like getting your foot in the door internationally, right? Setting a filing date, getting that initial search and opinion.
Exactly. Getting things started.
And then Chapter 2, triggered by this demand, is where you maybe roll up your sleeves and engage more deeply with the substance.
That's a great way to put it. It's the next layer, absolutely.
So this leads right to the big question, why? Why would someone choose to file this demand? You've already put time and money into Chapter 1. What problem does filing the demand solve, or what opportunity does it really create for an applicant?
Well, the primary and I think most compelling reason centers around addressing potential issues that were flagged earlier in the process. After the International Searching Authority does its work under Chapter 1, you get that international search report. But crucially, it also comes with a written opinion.
Ah, yes, the
Yeah.
written opinion,
Yeah.
which can sometimes be, well, less than thrilled about your invention's chances.
Precisely. That opinion might raise some significant objections. Things like novelty, is your invention truly new? Or inventive step, which many people know as non-obviousness.
Right. Is it a real step forward?
Exactly. Or even industrial applicability, can it actually be made or used? So filing the demand under Chapter 2 gives you a formal chance to respond to those objections. You can submit arguments, clarify things, and importantly, amend your application before it goes out to all the national patent offices around the world.
Oh, okay. So instead of waiting for your application to land in, I don't know, Germany, Japan, the U.S., and then having to argue about that same inventive step issue separately in each place.
Based on that same PCT opinion, yeah.
You can try and address the issue once at the international level during this preliminary examination.
That's the core strategic advantage. You're tackling potential problems head-on in a centralized way. Getting a favorable international preliminary examination report, often just called the IPE, that can significantly smooth the path. It can potentially expedite examination when you eventually enter the national or regional stage in various countries.
Okay, that makes a ton of sense. It's about efficiency, really, and strengthening your case proactively. So if you've decided, yes, this is the right move for my invention, how do you actually do it? What are the practical steps for filing this demand according to the MPP?
So the MPP lays out the key procedural requirements. First, you need to submit a specific form properly completed. The form for requesting this international preliminary examination is Form PCT IPE 401.
PCTIP 401. Got it. Always good to know the form number.
Definitely. And just submitting the form isn't enough, of course. You also need to pay the required fees. There are two main fees tied to filing the demand. There's the preliminary examination fee itself and also a handling fee.
Okay, examination fee and handling fee.
Right. And the MPP reminds us that these fees, just like the form, have to be submitted within specific time limits. Those are dictated by the PCT rules, specifically Rule 57.3. So hitting those deadlines for both the form and the money is absolutely critical. You can't miss them.
Got it. Form and fees. On time. Crucial. Now, you mentioned amending the application when we talked about why you'd file. Can you elaborate a bit more on that? What are the rules around changing your claims or the description or even the drawings at this stage?
Absolutely. And this opportunity to amend is, I'd say, one of the biggest benefits of filing the demand. You can indeed amend the claims, the description, or even the drawings before that final international preliminary examination report gets established.
So if that written opinion pointed out an issue, like maybe a claim was too broad, you could actually narrow it down here. Or, if the description wasn't clear enough, you could add more detail.
Precisely that. You use this phase to refine your application, often based directly on the examiner's feedback from that written opinion. But there are critical constraints. The most important rule is that any amendments you make must remain strictly within the bounds of the original disclosure of your international application as it was filed.
Right. No new matter.
Exactly. You can't add new information or features that weren't there on day one. You can clarify, you can narrow, you can explain better, but you can't introduce something entirely new you thought of later.
That makes sense. Standard rule.
It is. And if you do make changes, you'll likely need to file replacement sheets for the pages you've altered, description, claims, drawings, whatever changed. And critically, you must accompany these changes with a letter.
A letter.
Yes. This letter is your chance to explain to the examiner what you changed, where in the original application the basis for those changes can be found. That's how you prove you're not adding new matter, and ideally, why you made the amendments. Often you'll reference the specific objections from the written opinion. This letter is really vital for the examiner to understand your response clearly.
Okay, so filing the demand gives you this powerful opportunity to refine things.
Yeah.
But is everyone who files an initial PCT application under Chapter 1 automatically eligible to just move on to Chapter 2 and file this demand? Or are there specific criteria you have to meet?
No, it's not automatic. There are definitely specific eligibility requirements. They're outlined in PCT Article 31 and Rule 54. Basically, the applicant, or at least one of the applicants if you have several, must be either a resident or a national of a PCP contracting state that is specifically bound by Chapter 2.
Bound by Chapter 2, that sounds like an important detail. So not every single country that's part of the PCT has actually signed up for this Chapter 2 examination part.
That's exactly right. Most major industrial countries have, but not absolutely all of them. So, you first need to check if your country of residency or nationality is one of those Chapter 2 countries. And there's another piece. Your international application itself must have been filed with a receiving office of such a state. So, both your status and where you initially filed your PCT application matter for eligibility.
Okay. And what if, like you mentioned, you have multiple inventors or applicants listed, maybe from different countries?
Yeah, the MP clarifies that scenario. If there are multiple applicants, the good news is only one of them needs to meet that residency or nationality requirement for a state bound by Chapter 2.
Just one is enough.
Just one is enough. But if no applicant satisfies these criteria, none are from a Chapter 2 state, or the filing office wasn't right, then you simply cannot validly file a demand. The MPP says it will be considered as if it was never submitted.
Okay, so rule number 1, check your eligibility first. If you are eligible, you file the form, pay the fees, get this chance to strategically amend. What's the direct effect, then, of actually filing this demand? Does it lock you into anything specific down the road?
Well, filing the demand triggers something the PCT calls an automatic election. What that means is it automatically elects all the PCT contracting states that you designated in your initial international application, and which are also bound by Chapter 2.
It elects them. What does that actually signify in practice?
It's essentially a formal declaration. It's you signaling your intent to potentially pursue patent protection in those specific countries, at least through this international preliminary examination stage. It tells the international system and eventually those specific countries, hey, I'm serious about my application in your jurisdiction.
Gotcha. And the output of this whole Chapter 2 process is that International Preliminary Examination Report, the IPEA you mentioned earlier. How does that report actually function? when you finally get to the national stage in those elected countries? Is it like binding on the national patent offices?
That IPEA is a really valuable document, a useful tool. But no, it's generally not legally binding on the national or regional patent offices where you eventually enter the national stage.
Ah, okay. Not binding.
Not binding. However, it carries significant weight. I mean, think about it. It reflects the considered opinion of an experienced international examiner who has looked at your application, looked at your amendments, considered your arguments.
So it's more like a very strong recommendation, or maybe a head start for the national examiner.
Exactly. That's a good way to think about it. Presenting a favorable IPEA to a national patent office can definitely influence their examination process. It can help persuade their local examiner that your claims are likely patentable, potentially speeding up the whole process and maybe reducing the amount of back and forth arguing you have to do with that specific national office.
Less arguing sounds good.
Always. And some offices participate in programs like the Patent Prosecution Highway, the PPH. These programs specifically allow for accelerated examination if you have favorable reports from other participating offices, and that includes a favorable PCT International Preliminary Examination report.
The Patent Prosecution Highway, right? Another example of how these international steps can actually link up and help streamline things later. Makes sense. What about working with, say, a patent agent or an attorney during this Chapter 2 phase? Is there anything specific in this MPP section about representation?
Yes, Section 1864.04 does briefly touch on representation. It basically states that, generally speaking, the same agent or attorney who is authorized to practice before the receiving office where you filed your initial international application, well, they're usually considered authorized to act before the International Preliminary Examining Authority, the IPEA, as well.
Okay, so typically your existing relationship just carries forward into Chapter 2.
Right, usually it does. Now, if there are ever any questions about an agent's specific authority or right to practice before the IPEA, the MBA does mention that you can consult resources like the USPTO's own roster of registered practitioners, or there are procedures outlined in another form, PCT-IPA 410. But honestly, for most applicants, their existing agent just handles this phase too.
Okay, this is really starting to click now. Let's try and bring it all together with maybe a more detailed example. Can you walk us through a specific scenario? Show us how strategically filing the demand and using that amendment opportunity could make a real difference in practice.
Sure, let's use that common challenge we talked about. Inventive step, or non-obviousness. Imagine you file your PCT application, you get your international search report and the written opinion back, and the examiner says your invention lacks inventive step. They found a couple of prior art documents, and they argue that your claim solution is just an obvious combination of things shown in those earlier inventions.
Okay, a classic and often tough hurdle to overcome.
It really is. Now, maybe you firmly believe the examiner is mistaken, or perhaps you realize looking back that your initial claims were drafted maybe just a little bit too broadly. So instead of waiting to fight this same battle potentially in dozens of different countries later,
You decide to tackle it now.
exactly. You decide to file the demand under Chapter 2. You carefully analyze the examiner's objection, look at the cited documents, and you decide to amend your claims. Maybe you narrow the scope of the claims to really focus on a specific, non-obvious feature that perhaps wasn't emphasized enough before. Or maybe you amend the description, you add some experimental data you have, or further explanation that clearly demonstrates an unexpected technical effect or advantage of your invention. Something that helps show it's not just an obvious combination.
So you're using the amendment process strategically to directly counter that specific inventive step projection from the opinion.
Precisely. You submit your amended claims, maybe amended description pages, along with that crucial letter. The letter explains why these changes overcome the objection, and importantly, points back to where the support for these changes exists in your original application, proving no new matter.
Right, gonna have that basis.
Always. Then, the International Preliminary Examining Authority, the IPEA, re-examines your application, but this time with your amendments and your arguments right there in front of them. Now, if they are persuaded, if they look at your refined claims, your supporting explanation, and they agree that, yes, this now demonstrates inventive step over the cited art, they will issue a positive International Preliminary Examination report.
And that positive report, that's the payoff, isn't it?
That is the big payoff, because when you then enter the national stage in all those elected countries, you arrive armed with this report. A report from an international authority stating that, in their expert opinion, your claims are patentable, at least over the art they search. Now, remember, it's not binding.
Not binding, right.
but it's a really powerful piece of evidence to put in front of the national examiner. It tells them, look, this inventive step issue, it's already been reviewed, and the outcome was favorable at the international level. This often significantly reduces the amount of examination work, the back and forth, the arguments needed in those national offices. It can potentially lead to faster grants and quite possibly lower overall prosecution costs across your whole portfolio of countries.
Wow, okay. That makes the strategic value incredibly clear. It really is an investment, isn't it? Investing in getting that favorable international opinion early, which can then pay dividends in smoother, maybe faster, national prosecution pretty much everywhere you want protection. It's almost like getting a globally recognized stamp of approval early on.
It fundamentally shifts the dynamic, I think. You're moving from what might feel like a defensive position, just reacting to objections as they come up country by country, to a much more proactive stance. You're refining your application and getting an opinion that actively helps you in every subsequent national phase.
Okay, so let's just recap the key takeaways here. Filing the demand under Chapter 2 of the PCT, using MPPP 1864 as our guide, it's a key strategic decision point. It's not automatic. It's your formal request for international preliminary examination, separate from the initial Chapter I filing.
Right. A distinct step.
The main driver is usually that opportunity to respond to objections raised in the initial written opinion, especially on big patentability issues like novelty or inventive step.
Correct. Addressing problems early.
You do this by filing the specific form, PCT IPEA 401, paying the examination and handling fees on time, and crucially, using that opportunity to amend your claims, description, or drawings, but always staying within the bounds of your original disclosure.
And making sure you explain those amendments clearly in your accompanying letter.
And in return for taking this step, you automatically elect all your designated countries that are bound by Chapter 2, signaling your intent there. The output, that International Preliminary Examination Report, or IPR, even though not binding, becomes a potent tool. Especially if it's favorable, it can significantly influence examination in national offices later on, potentially speeding things up through mechanisms like the Patent Prosecution Highway.
Absolutely. It makes your whole journey towards getting patents granted worldwide potentially much more efficient.
So if we connect this back to the bigger picture, like you said, filing the demand isn't just another bureaucratic step or more paperwork. It's really a strategic opportunity, a chance to strengthen your patent application and proactively influence how it's going to be examined around the globe, which I suppose raises an interesting question for our listeners to think about. Given this potential, this ability to amend and argue issues like inventive step during preliminary examination, how might planning for this Chapter 2 stage actually influence how you draft your initial PCT application in the first place? Thinking ahead about how you might respond to potential objections later on, could that change your initial drafting strategy?
That is a crucial consideration. Thinking ahead, early planning. It's often the key to navigating complex systems like the PCT effectively. A very good point to ponder.
Absolutely. Well, before we wrap up, we definitely want to extend a special thank you to Mike Shepard, the creative director who organized this entire audio series.
Yes, thank you, Mike. And of course, we need to include our vital disclaimer. This deep dive summary of the MPE was put together with the help of AI tools, including ChatGPT and Notebook LM. While we've aimed for accuracy, it might contain errors or omissions. Please remember, this information is provided for general educational and informational purposes only. It is not legal advice, and you should definitely not rely on it as a substitute for formal instruction or professional legal counsel.
That's right.
For authoritative guidance on your specific situation, always consult the official MPEP document itself, talk to a qualified instructor, or seek advice from a registered patent practitioner.
Couldn't agree more. Understanding these procedures is so important, but the official sources and professional advice are absolutely your bedrock. We really hope this deep dive into MPEP Section 1864 has given you a much clearer picture of the PCT demand and the powerful opportunities it can present in the international patent process.
Thanks for joining us on this deep dive. It was great discussing it.
Join us next time as we tackle another section of the MPP, continuing our journey, cutting through the complexity to get to the core insights.